Hello, I'm attorney Sheri Abrams. My office is in Fairfax, Virginia, and for over 20 years I practiced special needs planning, Social Security disability, elder law, and estate planning. When your disabled child turns 18, a miracle happens in the eyes of the law. That child then is able to make all decisions for themselves, even though you have been making the decisions from day one. That is a big problem when you have a disabled child and you're dealing with the school systems or the doctors who are now not willing to talk to you. They want to talk directly to your child. And you may have a child who doesn't have capacity to make these decisions for themselves. If that is the case, then you want to consider going for a guardianship of your disabled child. Now, it's a big decision because you do take rights away from your child. The right to contract, the right to own a firearm, the right to vote in some cases. So therefore, you really need to sit down with a special needs planning attorney who does guardianships to see if they think that that is what you should do. I do those every day, and I'd be happy to meet with you if you're here in my area of Northern Virginia. Now, when do you start this process? You really should start considering this about 6 months before your child turns 18, or if you've waited and the child now is 24 or 30, we can still do it then. It's important to know that the procedure is straightforward and it is not something that is intimidating if you're being represented by an attorney. It's also important that you realize your child can do their own documents. They can do a power of attorney naming you. If they have the capacity to do their own documents, then normally they do not need a guardianship. Now, what happens when you decide, yes, your child needs a guardianship, or the doctors tell you you better get a guardianship? What is the procedure? Well, first off, you would come in and meet with an attorney such as myself. We would talk about it and we would decide if indeed the guardianship is what you're looking for. And a lot of times, the decision is almost made for you because your child is being taken advantage of by somebody, and you're afraid that they're going to wind up getting a credit card or buying a car or doing something that you don't want them to do, living someplace you don't want them to live, associating with people you don't want them to associate. All these things that you would be able to block if they were under 18. So we would talk. I would give you a form to take to your doctor. The form would allow the doctor to fill out and say whether or not the doctor thinks that your child needs a guardianship. If they do, we file a petition to the court in the area where you live. Fairfax, Alexandria, would go to Fairfax County Court, Arlington Circuit Court, and again, these are all to the Circuit Court. And I do all the courts throughout the area: Loudoun, Prince William, Fairfax, Arlington. So you get this petition filed, and the court then appoints another attorney called a guardian ad litem, or GAL, who will come out and meet with you and your child to determine if your child needs a guardian and if you are the right people to be the guardians of your child. Now, this is not a major visit. It's not like the police showing up at your house. It's somebody who is sympathetic to your situation and who is trained to do these types of visits. They don't represent your child. They don't represent you. They're the eyes and ears of the court. And so they want to make sure, the court does, because the judge can't come out to every house, to see how they're living and how disabled your child is. That guardian ad litem, or GAL, can also talk to the doctor, can talk to the school, can talk to anyone they really want to, family, friends, so forth, to make sure that this is the right thing for your child. Then the guardian ad litem will write a report to the court, and if the report says that yes, the guardianship is necessary, then We would go to the court on a Friday morning. It would be myself, you as the parents who are going to be the guardians, the guardian ad litem, and your child if they want to come. They don't have to come. So sometimes it's better for them if they don't come, just because a courthouse can be scary to some people. We would then go before the judge, and a few minutes later, the order is signed and done. Then I would take you to the probate office that corresponds to that courthouse, and then you would then get qualification papers showing you to be the guardian. You then would take these papers, and you should get several copies of them, 10 to start with, I suggest, and you would give them to the school. You would give them to the doctors. So therefore, they have to talk to you, not your child. You're standing in the place of your child, and therefore you're able to participate in a lot of these things that once your child turns 18, you're no longer able to do.